Dr. Ndeunyema is born and bred in Namibia, a very proud Namibian who had his B Juris and his LLB awarded by the University of Namibia. And then he went on from 2017 to 2021 to become the research director at the Oxford Human Hub, as well as the founding editor of the University of Oxford Human Rights Hub Journal. He's also an editor of the Oxford University Commonwealth Law Journal that was from 2016 to 2019. So his scholarship has been published in leading journals, including the Journal of African Law, Michigan Journal of International Law, and the Global Journal of Comparative Law. So his interests include, as I have indicated, international human rights law, public international law, constitutional law, competition law, the law on sentencing in criminal procedure cases and criminal cases in general, as well as criminal procedure. So in 2018, he also served as a legal fellow in the legal division of the African Court of Human and People's Rights in Arusha, Tanzania, and he is now currently a trainee solicitor. Just in case we think he's back, he's not. Unfortunately for us, but also fortunately for him, because obviously practicing law from, I think, a European front gives him such a platform to really advocate for the matters that he's passionate about. Just as not a brief reminder, but just as an offset, thank you so much, first of all, Dr. Ndeunyema, who's going to grace us with a presentation regarding the content of the book. Thank you so much for the Jacob Marengo Chambers, who are hosting us this evening. A special thank you also to Nambili Mata legal practitioners, as well as Shakwa Nyambe, legal practitioners just behind me, lawyers, and it's really strange that we are surrounded today by Advocate Werner Busak, who's a discussant in the matter. His LLM was regarding sort of petroleum, energy law, and that kind of thing. And we've also got really a leading law firm in that area of energy law that also really availed a sponsorship for this event that then congregates us today. So without much ado, Dr. Ndeunyema for his presentation regarding the book.
Good evening, everyone. Thank you so much for coming today. It's a delight to see many of you who are out here to support my scholarship and hopefully have a fruitful conversation on a very important subject matter. I want us to focus the substance of the evening to discussing the issues at hand. Firstly, I just want to also thank you, express my gratitude to Jacob Marengo Chambers, foremost through Nekwaya, who has really offered me the platform to unveil my latest piece of scholarship, as well as SNC, who came on with sponsorship, Nambili Mata, as well as Jacob Marengo. We value your financial commitment to seeing to it that our jurisprudence is developed. Secondly, to thank you to our two discussants who we'll hear from. I would like to think that I'm responsible individually for pulling this crowd, but I suspect that it is probably because Advocate Busak and Judge Masuku will be discussants. So I'm really humbled by the fact that they are willing to engage in this subject matter. Thirdly, the various faces around the room, literally almost everyone I know personally. So we would be here all evening if I were to express my individual gratitude. Now, to the substance of the presentation, we had wanted to have a PowerPoint presentation projected, but the lighting won't allow for it. So what we've done is we're arranging for copies of the presentation to be printed and handed out to you. So hopefully that will be printed soon and you can at least follow what I will be explaining. So the title of my book is Re-invigorating Ubuntu Through Water, a Human Right to Water under the Namibian Constitution. So many people ask me why that title. And I think once we get an opportunity to, please remove this. Once we get an opportunity to really get into the substance of the book, we will understand exactly why the title is as it is, the focus being on the human rights to water, but also having a much more African values premise that hopefully can inform the way, I argue, we interpret the Constitution. So I've been having various book discussion events over the last 2 weeks and a half that I've been in Namibia, and the aim is really for me to take the book, thank you so much, to the people and different constituencies and engaging with them, both law, people in the legal space, academia, people in the technical science space. We had a discussion last week, Wednesday, at the Namibia Scientific Society. NAM Water, they availed themselves for discussion. I went up in the north and we had engagements with various role players there. So this discussion is primarily going to be focused on the practicalities of how to ensure that we create, recognize, and are able to enforce the human right to water under the Namibian Constitution. Now, the contemporary water needs that we have in the country are clear, and there's a lot of debate around water and non-payment, water disconnections, the indignity of water scarcity, an example being of people who don't necessarily die of thirst, but die when they're trying to access water by digging traditional wells, and that has been well reported. As well as this peculiar situation that we have in the northeastern part of the country where there are water resources, but in order to access water for personal and domestic use, we see that certain communities have to risk life and limb in terms of the river crocodile incidences that are widely reported in along for communities along the Kavango. And of course, most recently, this issue of the water utility that we have in the country and whether it should be for profit, whether a markup should be charged for that purpose. Now, the situation isn't necessarily entirely gloomy. We have a lot of water potential in Namibia. We have the Oangwena Aquifer. We have desalination plant prospects, which government is considering of we have water catchment projects, which include most notably the Nakatal Dam. So certainly there are efforts that are in place to ensure that the water situation in terms of security, access and so forth is addressed in the country. But of course, especially now that we're engaging as legal minds, human rights are about individuals, human rights are about communities. So in as much as there is a large-scale infrastructure project within which government, for example, pumps billions of dollars, there are still individuals and communities whose right to water is being violated. So it wouldn't ordinarily be an excuse to say that, oh, we're investing in that piece of infrastructure, so your time will come. And we'll come to that at a later stage. But the book is definitely not navel-gazing. It seeks to be solution-centric and offering a legal solution through the courts to a pressing societal challenge. The book also takes a anthropocentric approach, so it centers human beings in this debate. And the reason why I focused on water for personal and domestic use is because in researching the subject matter at the early stages of my doctoral work, I tried to look at all the case law that relates to water rights in Namibia. Now, what I established is that all that case law, primarily in the High Court and some in the Supreme Court, is focused on water rights in the commercial context. So I identified three particular examples. So the first is a decision by the Supreme Court, Namib Plains farming versus Valencia uranium. The context here was water for commercial purposes as opposed to water for mining purposes. So the farmers who were farming for commercial reasons sued the uranium mine for over-abstraction of water, underground water. Another decision was between NAM Water and Alsenkier farmers, and this was in the context of breach of contract. So Alsenkier farmers were utilizing water for purposes of commercial wine production. Another decision, which is semi-commercial, was in a decision, I think, of 2005. I think a decision by Marcus A.J., as he then was, between Kamanya and Smith. And this was in the context where Mr. Kamanya was a Mangeti farmer. And he wanted to drill a borehole for his farming activities in that region. Mr. Smith was contracted. Mr. Smith breached contract, so he didn't deliver as per the contractual terms. And Mr. Kamanya sued him really for damages. But in his arguments, Mr. Kamanya made a right to water argument. So what I asked myself in looking at that and at those cases was, yes, we have effectively water rights rather than a human right to water that are and can be vindicated by our courts, but can the same remedial action be extended to the communities that I referred to earlier? Those communities that are contiguous to our rivers, those communities who are digging wells with their hands because water infrastructure hasn't reached them, and there's no projected plans to allow them to access water infrastructure and so forth. So is it possible to bring such a claim before our courts? So in so doing, obviously, we have to put up a robust legal argument. So the book sets out an argument in the following terms, and this is really to whet your appetites. Hopefully you will read the book extensively. So the conclusion that the book reaches is that there is indeed a court-enforceable human right to water, and that right is to be implied from the right to life from our Constitution. Because we are implying a right rather than relying on an express right, which is textually anchored in the Constitution, the theories of constitutional interpretation need to be carefully applied in the same way that you would if you were implying a term in a contract. For example, there is an approach to contractual constitutional interpretation. I know the test under English law, for example, and Namibian law would have a similar test. So I do so through an application of the various theories of constitutional interpretation. The approach that we are to adopt in terms of interpreting specifically constitutional Bill of Rights provisions. So I apply the various theories, including originalism, original intent, purposivism, textualism, and transformative constitutionalism. But the discussion of originalism is quite fascinating. So I did quite a lot of research in terms of trying to establish what was the thinking of our constitutional drafters when they omitted socioeconomic dimensions from our Constitution. And I relied on various resources. So I looked at the drafting history, the Constituent Assembly debates, which are short but do offer some ideas as to what their potential thinking was. The interesting thing about the Constituent Assembly debates is the fact that we had the 1982 principles that were effectively, if you want, imposed upon those who were going to draft our Constitution by Western states, which articulated what the structure and content of the Constitution would be. Interestingly, those 1982 principles refer to the fact that our Constitution, futuristically thinking, should have a Bill of Rights which reflects the Universal Declaration of Rights. If you look at the Universal Declaration of Rights, it includes as enforceable rights social and economic rights in relation to standards of living. Again, the Constituent Assembly debates don't necessarily give us the answer, but they are fascinating in that we are aware that there were technical advisors who effectively advised SWAPO on what became the main draft that was used for the Constitution. So the likes of Arthur Chaskelson, Vickers, and Erasmus, they working together. It's quite fascinating if you read the Constituent Assembly debates. They working together with as the technical committee with the political leaders in 1989 specifically, chaired by our current president, Hage Geingob, who was the chairperson of the Constituent Assembly at the time. So these issues weren't necessarily given treatment. But that's a whole rabbit hole that you can go down. And of course, in constitutional theory, there's this whole notion, what weight should we place upon the original intention of the founders of a given instrument? So, for example, in American contexts, the founders of the American Constitution, should they still dictate whether something such as the right to bear arms should retain its original intended meaning, or should we move on? So I don't necessarily place a premium upon that, but I recognize that some in the legal community may be persuaded by an original intent approach, and our Supreme Court, specifically in a decision called Kashela, which was a decision by DCJ Damaseb, refers to the intention of the founders as relevant in interpreting constitutional provisions. And of course, purposivism and textualism, those are established approaches to constitutional interpretation in our context, as well as transformative constitution, the constitution being an instrument for the transformation of society. Now, I am somewhat I recognize those arguments, and I argue that the right to water as an implied right is not defeated by applying any of those approaches to constitutional interpretation, but I also recognize the limitation of applying those approaches to constitutional interpretation and then put forward this theory of constitutional or reinvigorative constitutionalism, which I novelly conceptualize, the edifice of that being that our constitution requires us to reinvigorate African values for reasons that are located in decolonial theory, so having a more philosophical approach to constitutional interpretation, the reality that the project of imperialism also manifested through legal imperialism, and if we are to reverse that, we would also need to reverse legal imperialism as it still exists in terms of the values that inform our approach to constitutional interpretation. I find textual anchorage in the preamble of the Constitution. It refers, of course, to, for example, colonialism, apartheid, and so forth. That giving you voice and perspective as to how you should interpret the rest of the Constitution. Article include a right to your culture being reflected in your legal system as a society. And of course, Article 66, which in theory places common law and customary law on par, but in practice, common law is superior. It is what we have first recourse to, second recourse to, third recourse to when we have a legal issue that isn't necessarily anchored in legislation or the Constitution. So this notion of reinvigorative constitutionalism then seeks to demonstrate that the human rights project can have viability and value and retain cultural legitimacy by having recourse to our knowledge systems in order to really counter this argument that human rights are a Western imposition. So the slides are being handed out now. They're not numbered, unfortunately, but I'm moving on to the slide titled Water as a Constitutional Human Right. So you can turn there. The question may be posed as to why I build a rights to water argument as an implied right when legislation has a principle, at least, that refers to water in the human rights context. So the Water Resources Management Act of 2013, Section 3A, has such a provision, but of course I wanted to build the argument at that macro level in order to ensure that a right to water is an enduring principle that is not the subject of any given legislative majority, but it is within the protection of our Chapter 3 and everything that comes with locating such a right therein. And then again, the normative anchor of this notion of reinvigorative constitutionalism is through the value premise of Ubuntu. Of course, isiZulu, I am because you are, a humanist principle, giving it legal meaning. Some have asked me why Ubuntu, which is linguistically foreign. There's anthropological literature that I have relied on to demonstrate that Ubuntu, yes, is a linguistic variation of a isiZulu expression, but that value, Ubuntu, and I refer to specific anthropological literature that traces Ubuntu in its substance in African communities. The Ovaherero people, for example, refer to it as Umundu Menerovandu. The Kiriku people, I reference them, the Andonga people, and so forth. And the anthropological literature directed me to the reality that that suffix of nu, ndu, and tu, which cuts across various linguistic groups beyond the Namibian geographic territorial boundaries and even permeates this North Africa, Sub-Saharan Africa divide, refers to that underlying common edifice of communitarianism, solidarity, interdependence, and dignity from, specifically in the water context, a social justice point of view. I then argue that this then imposes positive obligations, crucially, upon specifically the state as the primary duty bearer, recognizing that other duty bearers exist, including non-state actors and third states potentially, but for purposes of the study, I focus on the state as a primary duty bearer, and the state at a national level, seeing that our political establishment is such that we do not have the same level of decentralization and devolution as you see it in even South Africa, and more specifically jurisdictions such as Kenya, which I reference because they have expressed rights to water in their constitution. So, of course, the socioeconomic character of our legal setup is clear. There's a focus on civil and political rights in Chapter 3, life, dignity, free speech, torture, political activity, right to vote, and so forth. We see that being vindicated frequently in our courts. So why not the same level of vindication of socioeconomic rights in our Constitution? Of course, there's a textual absence, which is the primary problem, but an interesting argument that came up in some of the debates that we're having, particularly at the UNAM book discussion event, is the fact that, yes, you cannot derogate or diminish from Chapter 3 as necessary political will, enhance Chapter 3. So effectively, this book in many respects would be redundant if we were to say that we're going to create a Chapter 3A or a Article 6 bis, which would specify these omitted social and economic dimensions. That is perhaps outside, strictly speaking, the judicial environment, but not quite, because if you look at Indian jurisprudence, for example, they also in 1949, when they drafted their constitution, did not have socio-economic rights such as education in their constitution. The Supreme Court of India progressively developed that jurisprudence, implying it from their Bill of Rights, specifically the right to life, and then the political world followed the lead of the judicial recognition of an implied right to education, and then all those, that the whole cluster of socioeconomic rights followed by way of amendment of the Indian Constitution. So perhaps some of the amendment of the Namibian Constitution debates that we've been having should also focus on these socioeconomic priorities, but clearly that is outside our remit as lawyers. I also look in the book and rely extensively on comparative cases, and I treat comparativism with carefulness and take lead from the Supreme Court's approach to comparativism, a decision, I believe, by our current Chief Justice, Shivute, in AG, Attorney General versus Minister of Justice, where he outlined the approach to comparativism that should be embraced. We have followed a different legal path, but there is still a role for looking over the fence, if you want, as a nation. So I look at South African jurisprudence. Yes, South Africa has an express right to water. But the jurisprudence there, such as Mazibuko, can teach us quite a lot in terms of the court's role in adjudicating such a right. But I also look at Botswana, which is somewhat neglected comparator in our jurisprudence, because Botswana has firstly similar climatic and geographic features as Namibia, and secondly, they also do not have an express right to water in the Constitution. But in this Mesolonyane decision versus Attorney General, the context was such that the Baswara community, which were part of the larger San people, were deprived of an existing use of an existing borehole. So there was a borehole that was government sponsored and so forth. The government of Botswana adopted a policy where they wanted to create a reserve, and therefore they effectively created a white elephant out of that borehole. So the infrastructure exists, but for other reasons, you do not maintain the infrastructure and deprive people from their use. They brought an action based on their right to not be subjected to cruel, inhumane, and degrading treatment. That was upheld by the Botswanan court. So an indirect way of effectively implying a right to water with the same outcome. But of course, that was more of a negative duty for the state to respect their right and not restrict their access to a borehole. Insightful, but not necessarily where we would want to be. Again, India, I extensively rely on India, not least because our constitution has also borrowed from India. It's not stated anywhere in the constitutional documents, but if you look at the language specifically of chapter 11, which is Principles of State Policy, you can see that it's in many ways a copy and paste, plagiarism, if you're less generous, of the Indian provisions. So India is clearly a relevant comparator in that respect, and their jurisprudence has also, despite the fact that they have directive principles of state policy which are entirely unenforceable, unlike our approach, established that there is implied right to water, for example, in the context where there was excess fluoride in certain water bodies. Now, at the Namibian Scientific Society discussion, we also extensively touched on this issue, where there are communities in the southern parts and some in the northern parts where there is excess fluoride. The treatment is often very simple, so who bears the duty? My argument would be primarily the state. So moving beyond the domestic setting, the human right to water at international level. So there's a whole chapter that is dedicated to the right to water or to international law and how it should be applied in the Namibian setting. There's a be applied. I have an approach. I call it qualified monism, digressing from the very helpful approach of Xhosa. Let's see what the Supreme Court decides. And I've dealt with this issue of what the status of the human right to water is under international law, so outside of the Namibian context, extensively in a journal article published in the Michigan Journal on international law. It's open access online if you'd like to read it. And I deal with the three sources of international law: treaties, customary international law, and general principles of law. Which general principles are neglected, so is customary international law. There has been a debate where some argue for customary international law, human rights to water, which would define domestic application under our Article 144 framework. But beyond the technicalities of international law and its domestic application, there are also these transboundary water concerns. So the dispute between Namibia, or the potential dispute between Namibia and Angola, much of north central Namibia has its catchment water area in southern Angola. Angola seeking to restrict the free flow of water. What are the implications for the rights to water under international law, because we can't rely on domestic law in that transnational setting for that community? Does Angola have an obligation to respect the Namibian population's rights to water? Equally so, our southern border with Angola, the dispute as to the boundary, who has ownership effectively of the Orange River. South Africa, as I understand it, arguing that the border to the Orange River is north of the Orange River, so they can claim effectively all of that as a water resource. in addition to the fact that there's canalling happening inland, restricting the free flow of water, in addition to the mineral resources that are lying in the Orange River. So all these are interlinked arguments that right to water under international law chapter hopefully can give us perspective on and potentially give us arguments in our collective defense against third states if we were to put forward the human right to water under international law arguments. There's also an interesting debate, somewhat antiquated now, but the whole notion of privatization. So neoliberalism, 1970s, 80s, World Bank, IMF, privatization of national infrastructure, Tanzania, Argentina, Bolivia, it ended in tears. The investors ended up withdrawing because of state nationalization. They sued the state. The state puts up right to water arguments for the reason why they nationalized in the context of privatization. Now, perhaps that can also at least inform us as a starting premise as regards our own debate here with regards to the privatization of water. Now, what is more perhaps fascinating about the right to water in the context of courts is this notion of justiciability. So, of course, we don't have a culture of socioeconomic rights enforcement, so naturally people would be apprehensive when courts are dealing with these issues that relate to policy, distribution of resources, and so forth. So there's institutional legitimacy concerns, separation of powers. The courts, unelected, is the executive and legislature who are elected. They have the primary mandate, and every 5 years you can hold them to account if they fail to deliver. I address that argument. Polycentricity, this image that a philosopher, Lon Fuller, puts forward of a spider web. These issues are so sensitive that if you pull, and you being the courts, on one strand of the spider web, it disrupts the entire configuration of the web. So an argument against the adjudication of these matters by our courts. I address this. Resource allocation questions, the fiscal squeeze that we face, basically this treasury versus judiciary debate, and so forth. I argue that or respond to that with a notion of bounded deliberative democracy, where the courts are the forum where the executive and legislature are held to account, that we see currently in our courts, but in a more didactic, dialogical approach, which I would argue is consonant with the African indigenous justice system's premise, latching back to how I would envisage and argue our legal infrastructure to be reformed in the direction of. And of course, Chapter 11, Directive Principles, I touched on it earlier briefly. Article 95 refers to directive principles which have some character as regards social and economic dimensions. I deal with Article 101. The argument in the book as regards principles of state policy is somewhat adumbrated, because in essence, the argument that I found my rights to water upon is entrenched within constitutional in Chapter 3 of the Constitution. So it has that framework protection. So, but I did recognize in the book that it's important to grant greater perspective to that chapter, Mulima versus Government of Namibia, which I think the LAC brought on behalf of the treason trial then accused, now convicted, in terms of the right to a fair trial, in relation to the right to legal aid, a policy principle in Article 95. I critique that decision in as much as it was progressive at the time. The only other time that the Supreme Court dealt with any issue related to Article 101 was in the context of SME Bank versus Bank of Namibia, where the argument was put forward that because of Article 101, the bank's role in that commercial dispute was restricted in some way or shape. So there isn't extensive treatment. There is, you may be delighted to hear, an article by myself in the pipeline on that very subject matter, where I argue fully what the true meaning, I argue, of Article 95 and Chapter 11 should be. It has come back with revise and resubmit. So you'll have to wait a few more months probably for it to enter the public domain. But I think that will at least move us away from this argument that because we have Chapter 3, Chapter 11, pardon me, and Article 95, then all these socioeconomic rights are outside the potential remit of justiciability. The next slide is on avoiding the mirage of justiciability. And here I effectively argue that, yes, at the end of the day, we can recognize an implied right to water, and that such a right can be court enforceable, but there are all these other mechanisms, ways, prohibitions as to realizing that right to water. I identify, for example, access to justice as an issue, prohibitive legal costs. If you were to bring a social and economic rights claim before our courts against the state, you would, of course, at the forefront of your mind, have the concern that you have legal fees to pay. You know, the choirs of these chambers. In addition to that, potential punitive cost order, and how that may stifle our ability to create a right to water. But at the end of the day, it becomes theoretical and illusionary because of the way in which we have set up our constitution. So the book and its cover, and the photographer, I think I saw her here, who took the cover image of the book as a photography, I think captures that issue of the mirage of justiciability quite well. So if you acquire a copy of your book, and please do acquire a copy of the book, you will see that there is this image of a petrified tree in a body of water, and that tree, yes, it's in a body of water, but it's leafless. Of course, a tree in African culture has a lot of metaphorical significance in terms of where we resolve our disputes. But this tree cannot offer us refuge because it's leafless, despite it being in a body of water. You see that if you turn the book upside down, as people often try to correct me when I'm taking a picture with the book, you see that it actually does make sense, because it does seem as if, because there's this optical illusion around the water, is arid and deprived of water despite its proximity to water, which is an apt metaphor for many communities who actually have proximity to water but have deprived water. So this is not necessarily an invitation to judge the book by its cover, but if you did, I don't think you'd be disappointed. So those are some of the issues that I tease out in this discussion of the mirage of justiciability. And eroding this approach to adversarialism in our courts, where it's you against me, which isn't consonant, as I mentioned, with African values. We can come up definitely with a different design, and we wouldn't necessarily be reinventing the wheel because it has been done in other jurisdictions. And of course, the content of water, once you recognize the right to water, would be pertinent. I rely on various soft law sources in terms of developing what that content is, and I justify why these soft law sources are reliable within our legal framework. The WHO's Drinking Water Guidelines, General Comment 15, the African Commission's Nairobi Principles. I developed, in an act of remarkable innovation, this notion of aqua, which is water that is available, of quality and accessible, but this is really a tool to allow the reader of the book who wants to deploy it for practical purposes to then have a framework. Okay, available. Is water economically available? Is it physically available? Is there a discrimination element to water? Quality. issues with regards to putrid water, fluoride, heavy water in terms of milligram content, water that interestingly is odorous. African Commission identifies that as a problem, and water that is not necessarily hazardous in terms of health, but aesthetically it's problematic, and that is identified. The dirty water, the water that you can clearly see is dirty. That is also a quality dimension that is to be focused upon, and that is relevant to those communities that are relying on such water sources in wells and so forth. And of course, the accessibility point, proximity. There's a table in the book that at least gives you an outline as to what the international standard is per the WHO. And again, I identify the state as a primary duty bearer in that respect. An interesting discussion that I hope we can have some reflection on is that in the context of the content of the right to water, I make an argument for a minimum core that each and every individual and community should have. And I make that argument. There's a whole debate under international law about the minimum core, that every right has a minimum core, so the state has to provide you with a specific content of water, for example, or food, health, of a certain standard and the like. But interestingly, I rely on Article 22A, which is part of Chapter 3, to put forward the argument that the language of essential content of every given right in our Constitution is the synonymous equivalent of the minimum core, and I rely on the literature that commented on the development of the minimum core at the level of the ICCPR in the 1970s, 1980s, and that effectively being reflected therein. Another decision of the Supreme Court, Alexander versus Minister of Justice, the context here was a right to liberty argument. The Extradition Act at the time absolutely prohibited anyone who was being subjected to extradition proceedings from being granted bail. The Supreme Court held that the non-derogable essential content of the right to liberty, which I believe is Article 7, was violated by that statutory provision. So a similar argument can be potentially made, and this is a low-hanging fruit argument to say that there is an essential content minimum core of the right to water, and there are communities whose minimum core is not being recognized and realized, and the duty bearer primarily is the state, in as much as there may be other duty bearers. So that is a potential argument that can also be advanced, and of course the minimum core would be immediate, so you cannot say, oh, actually we have a plan of action for you 5 years down to provide you with water. And of course, there is a minimum core and a circumjacent to that minimum core, the circumjacent then being the general obligations that would be progressive, but still, I argue, subject to judicial accountability. So that oversight role that the courts can play is important in that respect. So that's the end of the substantive aspect of the presentation. The penultimate slide was really reflecting what is reflected on page Roman numeral 7 of the book, and that is to whom the book is dedicated, and that is late Professor Effa Okupa. I think it's appropriate to acknowledge her. She's no longer with us. She was a professor of law at the University of Namibia, as well as at SOAS. There's some pictures of her there. And she, in many ways, inspired much of my legal thinking and my drive to pursue an education. And I remember in the weeks before her passing, I was struggling as a DPhil student to secure funding to continue my studies, in as much as I had a place at Oxford, and we were going around Oxford. If you know London, Professor Okupa instructed me to come down to London, and knowing Professor Okupa, she was like, we're going to knock on every door, Ndjodi. You're not going home without a PhD. Over my dead body. Those of you who know Professor Kupa will know that she researched the afterlife. So I did not dare, despite her demise, return to Namibia without a PhD. So I dedicated this book to her posthumously. I see a number of her children, as she calls them. I see Meme Zamwani here and various other students of her. So I think she also had a commitment to African values, African customary law, those who are marginalized in society. And this book, over and above its substance, is meant to honor that legacy. So that is that in terms of my presentation. Thank you very much for your attentiveness, and I look forward to further engagement.